I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Privacy and the First Amendment. It's a really interesting issue that has caused many to speculate on the future of many data-related legislative efforts, especially with current jurisprudence moving in the direction of expansive views of protected speech. Where does that leave U.S. privacy today? Well, we have our first indication following a Ninth Circuit decision relating to challenges to the California Age-Appropriate Design Code. That code, which was designed to protect children online, including on social media, included provisions that would require the creation of data protection impact assessments, or DPIAs, which the court found to be unconstitutional. That could be a big problem for data protection policymakers because DPIAs are a common component of data protection law today, especially those which are inspired by the GDPR. So that's our focus on today's episode. Are DPIAs constitutional? And what impact does the Ninth Circuit have on other DPIA requirements that exist currently? To discuss, I've invited my two colleagues, Harsimar, Dhanoa, and Ryan Thompson, to the podcast. Both Harsimar and Ryan spend much of their time tracking and leaning into policy developments around the world in both courts and legislatures. Harsimar, Ryan, welcome to the podcast.
Thanks for having us.
Glad to be back on.
Ryan, maybe the first question I have for you is the actual underlying litigation here wasn't specific to the constitutionality of data protection impact assessments. It was really brought against the California piece of legislation designed to protect children online. Interested in what did that law say and why was it drawing so much scrutiny?
Sure, yeah. So the law, the California Age-Appropriate Design Code Act, generally understood as the AADC, it was signed into law in September of 2022, and it had several provisions in addition to the data protection impact assessment requirements, or DPIAs. So the data protection impact assessments, they basically required any company offering a service that was quote unquote likely to be accessed by children to create a report for any of those services to assess essentially like any risk of material detriment to children. And there are several different types of risks that were identified, but the DPIA requirement didn't address what the harm was that the law was targeted at. And then in addition to that, the law also imposed age estimation requirements for companies. They required high privacy defaults for children. It imposed profiling of children, prohibited monetization of children's data, and prohibited dark patterns. And so there were a number of pretty robust requirements that go beyond the typical privacy laws that you see in states enacting throughout the United States into something that's much more robust in terms of just overall protection for children online. And so the law was enacted in September 2022, and it was challenged in the Northern District of California shortly thereafter. And so there were a number of different constitutional and statutory challenges that were brought, but the focus of the litigation was on the First Amendment, the argument principally being that the law was compelling speech for online platforms and services that they may not want to carry, and that they basically were also restricting speech by requiring companies to create these reports that required them to assess the risk of harm from third-party content. And so the district court in September of 2023, they agreed with the litigants and they found that those DPIA requirements were facially unconstitutional. And they also concluded that there was no provision of the law that was severable. And so the entirety of the law was enjoined. And then California then appealed that decision to the Ninth Circuit. And there in August of 2024, the Ninth Circuit partially affirmed and partially vacated that lower court decision, basically saying that the lower court was right that the DPIA requirements did violate the First Amendment, but that the lower court would need to do further analysis with respect to the other requirements of the law, like age estimation, high privacy defaults for children, profiling, etc.
Yeah, I mean, that's really interesting. And I want to dive deeper into the legal challenges and why the Ninth Circuit came out the way that it did. But maybe just spend a moment and think about the context in which this is being brought up. And frankly, the challenge that policymakers and legislatures are having with a really difficult set of issues. And if I understand kind of the purpose behind the California Age Appropriate Design Act, was really designed to try to protect kids, probably primarily online, but primarily within social media and the exposure that many of them face to online bullying and online harms, which are very difficult to detect and also can have significant impact on individual lives. And so what we have here, Harsimar, is California's attempt to try to say, listen, we're not going to be in the business of telling you, social media operator, that you can't operate your business. But what we want you to do is to evaluate how kids may be using your platform, and importantly, how the use of that platform may result in any number of harms to those children. Do I have that right?
That's right, Scott. So that is the principal argument behind lawmakers in California. The challenges start to come up when you get into the nitty-gritty of effectuating that, because I think everyone would agree that keeping harmful content away from kids is a worthwhile goal. The problem is that you have different people who will say what is considered harmful. And so in this case, the Ninth Circuit really was looking at when you have a business sort of making an assessment of, okay, is this going to be a risk of harmful content? The business needs to opine on what it thinks is harmful in this instance, which may be speech that they weren't otherwise doing. The law also sort of talks about mitigating those risks. And so you now have a place where a business's assessment may not align with what a regulator thinks is harmful content. And that can also cause areas where a regulator may say, listen, we think that this type of content is harmful, so how are you accounting for it? Which may pressure businesses into essentially self-censoring them.
Yeah, so it's like if you're saying, hey, business, you need to evaluate to what extent children are going to be exposed to harmful content. Is harmful a defined term, or is that left to the business to determine what is harmful? Because I can imagine, and this is, some of the difficult aspects of First Amendment cases, is that when you are imposing vague standards and then forcing organizations to decide what's harmful and what's not, you can result in all sorts of different conclusions. For example, there's probably half of the country who think that political discourse advocating the other half of the country may be harmful to kids. And that's the type of content that would fall squarely within the contents of the First Amendment, or what the First Amendment would be designed to protect. So is this really a case where businesses are perhaps being forced to evaluate what the contents of speech, to label that speech as to whether that's harmful or not? And that is the crux of the problem?
I think that's a key part of it. And really, you have to think about, when you have something like harmful content, nobody wants to be the business that took a conservative view of what would be considered harmful and then have the finger pointed at them for not doing enough. And so it incentivizes implicitly to take a broad perspective of what might be viewed as harmful. I love your example about political content, where she would say it's an important part of discourse in the country. And you can see a company saying, listen, there might be political speech that may have value, but because it might be potentially harmful to kids, we're going to put limits on that. So without even the government saying, hey, you need to go and target a specific type of communication, it sort of had chilling effects on content that will be on those businesses' platforms.
And this is not a case where the court is saying that a business can't voluntarily decide to put restrictions surrounding what constitutes harmful contact around children. It's the case that the government, in this case, the state of California, is telling them that they have to be able to put those confines around those. And maybe, Ryan, from your perspective, as I'm trying to understand, how these issues are popping up, you're saying the net choice, when they were brought this case, one of the arguments was that you are forcing an organization who is subject to this law to not only make these arbitrary decisions about what's harmful and what's not, but then to articulate that into a data protection impact analysis or assessment, which itself is a form of speech, and that is almost a compulsion of speech.
Yeah, so a fundamental tenet of the First Amendment law is that the First Amendment protects both the right to speak and the right to not speak. And so the Supreme Court has developed an analysis around these sorts of issues and built some additional leeway for when the government is working with regulation of speech that is more commercial in nature. And so the way that the courts are going to look at this is to, first assess whether this is speech that is, being compelled. And so is it, conduct versus speech? You could actually have, some wiggle room there. And here, because there's a data protection impact assessment and there is an actual written document that the attorney general can compel a company to produce, it's clearly speech. And then so, the next question that comes up is whether the speech is going to be commercial or non-commercial in nature. And then so if it's non-commercial in nature, then it would be the level of protection from the First Amendment would be strict scrutiny, which is the highest level of constitutional protection for speech, including compelled speech. And then if it was commercial speech, then it depends on the type of commercial speech. And so if it was purely factual and uncontroversial speech, then it's similar to the level of protection is fairly minimal. It's called the Zauder standard, but it basically says that as long as the speech regulation is not unduly burdensome, the government regulation is constitutional. And then if the commercial speech is not purely factual or it is controversial in some fashion, then intermediate scrutiny would apply. And in that case, then the government would need to have a compelling interest, and the tailoring of the law itself needs to be pretty close to what the objective is, the interest that they're trying to serve. And so the court did not focus too much on the compelling interest issue. Seems like, protecting children online is a pretty compelling interest. And so most of their analysis was focused on this tailoring piece. And so they first had to assess whether the data protection impact assessment was commercial or non-commercial. And there, they said it was not commercial because typically, and the Supreme Court has enumerated a test for this called the Bolger factors, where they're not dispositive, but they're a good indication of what is commercial speech. And they focus on whether it's like in an advertising format, if there are product references, and if there's a commercial motivation for the disclosure. And the court in this case said that it basically fails on all those fronts. The data protection impact assessments do not meet any of those requirements. And so the court concluded that this is non-commercial speech. And so then the court got to this tailoring issue, and there they looked at other potential alternatives that the California could have adopted instead of this data protection requirements. And so they listed, for example, incentivizing companies who offer voluntary content filters, or educating children and parents on the importance of using tools, and relying on existing criminal laws that prohibit unlawful conduct. And so they said that you have all these other tools in your toolbox that you're not using. And because this is requiring companies to essentially opine on, vague harm that any two persons could have, different views on, that this does not meet the standard for narrow tailoring. And thus you have failed to satisfy the strict scrutiny that you must satisfy if you want this law to be constitutional.
So, Ryan, one important thing that I'm thinking about as I'm hearing your description is that the required DPIA under this California law, it was certainly a requirement to speak, but there are many other laws in the United States within privacy laws or non-privacy laws that speak to and require organizations to create all different types of disclosure and all different types of speech. So think, for example, every publicly traded company in the United States having to produce SEC filings, which are voluminous, and I think many of them would say are burdensome and expensive. So interested in your perspective, did the court go so far as to say that any type of forced disclosure oriented laws, forced record keeping laws was now subject to this level of constitutional scrutiny?
No, no, this was not really changing the constitutional analysis, and the court did not call all compelled disclosures into question. And so it's really, there are like multiple ways the government can satisfy its burden. And so one of them is that the speech that is being compelled is quote unquote commercial in nature. And then if it's, purely factual and uncontroversial, then, that's a very easy standard for the government to satisfy. If it's commercial, but it does not tick both of those boxes, then it has it has to have a compelling interest, and there needs to be a good fit between what they're trying to compel and, that interest that they're trying to serve. And then, of course, also, even for non-commercial speech, there's also a way for the government to satisfy that burden as well, but the standard is even higher. And so what the court said here, though, is that very high standard, you did not satisfy it, but they did not call into question other disclosure requirements.
So, in other words, some mandatory speech laws, almost, for lack of a better phrase, are constitutional. And then we're getting to, this area where we're trying to decipher what's going to be subject to what level of constitutional scrutiny, and what is perhaps maybe that's an area that has been settled in other laws, but what is new and different about this one, and the reason why we're talking about this on a privacy podcast and a cybersecurity related podcast, is that this is now, I think, for the first time being debated in the context of DPIAs, which are often a tenet of new and emerging data protection laws in the United States and have long been a central tenet within the European Union for under the GDPR. So, Harsimar, interested in your perspective, how to make sense of all of this. Does this mean that DPIAs are going to be a thing of the past in the US, or do we think that's really still an open question not addressed by this decision?
So the Ninth Circuit tried to sort of preempt this concern, but there's still been a lot of heartburn in the privacy community about what this decision means for DPIAs in the privacy context. The Ninth Circuit essentially said, it's not so much that a business can't be required to think about the risks that their design or their data management practices might impose, which is typically what a DPIA in the privacy context covers. Here in the AADC context, it's the fact that this is focusing on content in particular and harmful content to children, that the Ninth Circuit sort of said, okay, this is the dividing line. If you're not going to focus on content, context, etc., that's sort of what separates the AADC from the rest of these laws. That said, I can imagine a court taking a much closer look at DPIA requirements in the US to say, okay, you are asking companies to look at the benefits that flow from their data processing and the risks that might come out of it. And typically these laws will include some language or provision saying they're not meant to infringe on First Amendment rights. And I think what we may see is just a closer level of review at those DPIA requirements to say, okay, you are requiring people to assess the risks, but is it being done in a way that is forcing them to opine on, certain types of speech that are harmful or not? In the case where DPIA can now look at similar factors without necessarily reaching that level of needing to personally, as a business, opine on what is harmful and what is not, we may see DPIA requirements come out unscathed, but it still is somewhat of an open question overall of, is this just purely factual information, or do you actually need to, do you cross the line when now you're saying I'm evaluating certain risks and how I want to mitigate them?
as you're describing kind of what the key elements of a DPIA is and however it is you're doing the analysis, I mean, effectively, these are documents that are designed to demonstrate your compliance with laws and describe your data processing and reflect how that meets the relevant legal principles underlying that and some of that, could have value components. For example, if you're thinking about doing maybe slightly differently, like a legitimate interest analysis under the GDPR, you're evaluating, the interest of the organization in processing the data versus the interest of the individual not to have her or his data processed. And as a result, you are doing some level of value-based kind of analysis in that type of work. And it seems as though what this case does is it really starts to make regulators and legislatures think about what they are requiring to be included within the DPIAs and perhaps what they shouldn't be requiring to be included within DPIAs.
I think that's right, Scott. A few, I think, reactions I wanted to share. One is, I think you're right to say that some portions may be less controversial, under this decision and under the First Amendment scrutiny than others. Things like saying you need to document what types of data are being processed, how that data is going to be used, factual information. That is probably going to fall in that commercial speech bucket that Ryan was talking about earlier, where it may be uncontroversial and receive a lower standard. But once you start getting into, okay, well, start providing an opinion on which pieces are, present risks and how you're going to mitigate those, that may sort of raise the temperature on the conversation slightly. In terms of the practical impact, I don't know that lawmakers are going to be, firmly choosing to pare down their data impact assessments, primarily because we've seen such consistency across the states. For the most part, I will say outside of California's recent, the rulemaking that they're considering on risk assessments, we've generally seen a great deal of harmonization on those requirements. And so lawmakers may want to say, listen, we will align with where our other states are. And if a court comes down and says that we need to pare this back, then we'll let that control in this instance, but we won't affirmatively take a sort of narrowed perspective on there. But that is probably, where lawmakers may line up just because of the benefits of harmonization across the board. And the final piece, I think that is important to describe, because you had mentioned the legitimate interests assessments in the, under the GDPR. Interestingly enough, the California Age Appropriate Design Code was actually modeled after the UK Age Appropriate Design Code. And, one of the interesting things here is I think we're starting to see a bit more of the gap between some of the frameworks that are available in Europe and how those play out under their broader legal framework, and how trying to import them directly into the US is causing challenges, just given the fact that we have additional First Amendment protections that complicate the landscape and make it so that it's not necessarily going to be a copy the language from Europe, bring it directly over to the US and just go forward.
Yeah, really, really good point, Harsimar. And maybe as we wrap here, I'm interested in maybe one other dynamic, because while California, I think, was the first state to have the age appropriate design code enacted, it is not the only state that has done so. What does this decision mean for other states who are also looking to try to protect kids online with similar, maybe UK inspired legislation?
So Maryland is this big state that came in as the second wave of these age appropriate design code laws. They're the second state to actually have one passed after California. And they had taken steps, based on some of these challenges, to remove some of the references to content to, widen that gap between what the court was looking at here and what what we actually want to accomplish. Interestingly enough, though, they still kept language in there around preventing access to, harmful or potentially harmful contacts. And so we may see pieces from this decision still bleed over and impact Maryland's age appropriate design code, because a business would still need to think through, okay, if we have this processing functionality or, this ability for people to message folks, Is that going to lead to a harmful contact? Who are we considering to be a harmful contact? In a similar vein of, is this harmful speech? And what are we going to do about it?
Yeah. Again, going back to that value-based, content-based type of determination or decision-making, one person may see a harmful contact very different than another person may see that same harmful contact. And as a result, kind of then pushes the organization in the position to be making that content-based decision-making.
Exactly. I mean, the clear example of this one is around messaging for users who don't have an affiliation with one another. Oftentimes you'll see as one control for under 18 accounts is let's limit who can actually send someone a message to people they are already friends with. But you can also see some companies saying, listen, if we do that, does that undermine the ability for users to actually network in the same way, to fully enjoy, the benefits of the community on our service, which again leads to this opining of, well, where are we going to draw the line?
Yeah, fascinating. Well, many more developments I expect to happen in this space as policymakers and our society in general struggles with these really difficult issues, while at the same time kind of managing and staying true to the constitutional principles that underpin our legal system. Harsimar, Ryan, really appreciate your insights on today's podcast, and we'll be sure to have you back on future episodes to discuss developments in the space.
Thanks, Scott. It's a great conversation.
Thanks, Scott.
With that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.